When the defendant did leave the home, she took almost everything. Everything from the home, all the way down to the bath towels and the dishes in the house. We do have photographic evidence of this. My client is currently working on a list of property that he would like returned to him.
This matter is before the court on the plaintiff's motion for temporary custody, exclusive use, return of property, and other relief. And the court does note that Ms. Henderson has filed an answer. I've reviewed that. Ms. Podolsky, you can proceed.
Thank you, Your Honor. I would note that this was filed on February 7th. The court was kind enough to allow us to schedule this for a Wednesday motion hearing on February 22nd, but due to the ice storm, we did have to cancel it, and it was rescheduled for today. These parties did reside together up until the time of filing and February 6th, 2023. They have 2 minor children together. At that time, the defendant did move from the marital home. I do not believe there is a dispute over awarding exclusive use of the marital home to my client. I believe that has been resolved. However, as it relates to custody and parenting time, there is no order in place. While these parties have been able to somewhat work together, a specific schedule does need to be ordered. These parties have both been with the minor children since birth. However, it has been the defendant who has absented herself from the home over the years for significant periods of time, with one period lasting up to almost 1 year entirely. The plaintiff has been the primary caretaker of these minor children. He has been able to ensure that they are cared for while he is at work. He handles their schooling and all of their medical needs, despite the fact that he does have a full-time job that sometimes has some weird hours because it is factory work. However, he does have family in the area who are able to help him when he does have to work. The defendant, to our knowledge, does work at a restaurant. She often works late nights because of the hours of the restaurant. We do have a proposed schedule outlined in our motion that we believe would be in the best interest of the minor children and also accommodates the work schedule of both parties. As previously stated, it has been the defendant who has absented herself from the home. It is leaving plaintiff to be the primary caretaker for these children. We do believe it is appropriate at this time to award the parties the joint physical and legal custody of the minor children. We are asking for the parenting time schedule that we've outlined in our motion to be ordered. When the defendant did leave the home, she took almost everything from the home, all the way down to the bath towels.
Why, that Grinch even took the last can of Who hash.
And the dishes in the house. We do have photographic evidence of this. My client is currently working on a list of property that he would like returned to him. And I do believe we can work that out with defendant's counsel to assure the return of any of that property. So today, I believe the issues that do need to be addressed are custody and parenting time and child support.
Okay, thank you. Ms. Henderson?
Thank you, Your Honor. That is correct that we are not contesting exclusive use being granted to plaintiff. My client has no desire or plans to return to that home that is owned by plaintiff's father. It is untrue, Your Honor, that plaintiff has been the primary caretaker of the children. The children are currently 9 and 12. My client has arranged her work schedule to be flexible enough to be able to get the children to and from school. And then she has family members watching them a couple nights a week that she does work. She never works past 9 o'clock. She is able and fit to provide care and custody for the minor children. We outlined in our response to the motion, Your Honor, plaintiff's work schedule that is on average 100 hours a week or more, where he leaves the house early in the morning, does not come back until 11 o'clock in the evening at night. He works most weekends, and so far since the separation, any time that he was not working and asked my client to see the children, she accommodated that. So essentially, if he is granted joint physical custody, the children will be in somebody else's care rather than his care, simply due to his unavailability. He works in a factory with mandatory overtime. It's not something he can flex or change his schedule to accommodate the children. My client is able to do that. We provided her work schedule in our response to the motion. She works Wednesday, Thursday, Friday, and Saturday nights. And she is she works Thursday, Friday, and Saturday from 4 to 9 p.m. and the first Sunday of every month from 10 to 3 p.m. And at that time, the children are able to come to work with her and do homework and whatnot, be supervised at that time. So, Your Honor, my client is absolutely able and willing to provide care for the children. Previous separations of the parties occurred prior to filing for divorce. They were all due to domestic violence against my client by plaintiff. There is currently a personal protection order that entered by this court and was served upon plaintiff last night.
Wait a minute, wait.
So, Your Honor, that should absolutely be considered by this court in making a determination on custody and parenting time. We're asking that my client be granted physical custody of the children, with plaintiff having parenting time when he's available to provide care for the minor children. Again, that may be difficult for the court to determine given his 100 hours plus per week of work time. We're asking that child support be granted in accordance with the Michigan Child Support Formula. We're not disputing exclusive use. At this point, we are not disputing joint legal custody, as we understand that is the default of this court. So, Your Honor, joint physical custody is not in the best interest of the children. We're asking that my client be granted physical custody. One other portion of the motion was related to Concord schools. We're not objecting that the children remain in that school district. In fact, my client secured her housing within about a mile from the marital home so the children could continue attending that school district. So that is not something that we are contesting at this point. Thank you, Your Honor.
Thank you. Anything else, Ms. Podolsky?
Thank you, Your Honor. Since the filing of this motion, my client has been able to change his work shift to the first shift at the factory. As you can see, he's trying to connect to audio and he is at work right now. We deny that he is working 100-hour weeks. Yes, there is overtime at work. However, it is never a guarantee, just like any job. We do believe it would be very inappropriate for these minor children to be going to a restaurant and bar to do their homework and wait for their mother to get out of work. We do believe what is in these children's best interest is to have a schedule of joint physical and legal custody with the schedule we have outlined in our motion to accommodate the work schedule of both parties. We deny that there has been any domestic violence in this matter. I understand, as counsel has stated, that a PPO may have been served last night. I have not seen that PPO. I understand that one was requested and granted several weeks ago, actually back in February, but was never served on my client until apparently last night, the night before this hearing. Since the entry of that PPO, however, the parties have been having parenting time exchange and cordial communication regarding the minor children. So I just find it interesting that she waited until the night before this hearing to serve that PPO. We do believe that is disingenuous. So we are asking this court to enter an order of joint physical and legal custody with the parenting time schedule that we outlined in our motion. We'd agreed to continue school at Concord schools and exclusive use of the marital home to my client.
Okay. Well, apparently it's not in dispute is that the children would stay in the Concord school district, so the court will order that, as well as grant plaintiff exclusive possession of the marital residence. As that's not in dispute, it's not in dispute either that the parties would have joint legal custody. So the court will grant that as well. As it relates to the physical custody, what the court's going to do in this matter, the court is going to grant joint physical custody to the parties based in parenting time based upon any schedule that the parties can arrive at as mutually agreeable. If they cannot agree, then it will be alternating weeks on exchange on Friday at 6 o'clock p.m. through the following Friday at 6 o'clock p.m. Support will be consistent with the schedule and the guidelines in this particular matter. The court will not take any preliminary matter as it relates to the personal property, allow the parties to attempt to work that out. If they're not able to work that out, then we will address it at a future hearing. So, Ms. Podolsky, you can prepare that order and submit under 7-day notice.
Thank you.
Okay, thank you. Court will end this matter at 9:26 a.m. You're free to go. Have a good day.